So you got this notification in the mail about your 341 meeting of creditors, and you are thinking, oh my goodness, what's going to happen? Maybe you're picturing a courtroom with a big, nasty judge who's going to slam down the gavel and say, your case is thrown out. No, no, no. That is not what a 341 meeting of creditors is about. So let's talk about it. In the Northern District of Georgia, number one, your hearing will be conducted over Zoom. When you get your notification in the mail, it's going to have the link, it's going to have the code that you need to type in. And you really probably need to block out, just to be safe. Yeah, I'd say at least block out 3 hours for it. It's not going to take that long. 99% of the time, the hearing lasts maybe 5 minutes, but you need to have that time blocked out just in case. You need to dress appropriately, professionally. It is recorded and it will be a matter of court record. Now, I shouldn't have to say this, but I'm going to. Sometimes, believe it or not, some people will try to do their 341 meeting while they're driving. No, don't do that. You can't do that. The trustee's not going to hold the hearing. The hearing's going to have to be reset. Your attorney is going to have to charge you again for another 341 hearing because it's going to have to be reset out in the future. Don't do that. Make sure that at the time of your 341 hearing, number one, you're in a good, quiet place so that everybody can hear you, so that there's no internet disruptions. Make sure you have a good, solid internet signal. If you have to drive to your attorney's office, make sure there's no issues with your 341. Now, let's talk about who the Chapter 7 trustee is. Almost all of the trustees in the Northern District, Georgia, are nice people. There's one in Atlanta, not so nice. Your attorney will know who that is. But even that one, it's that trustee, he's not the end of the world. He just might take longer and might have some attitude, but nobody's going to belittle you or say nasty things about you. That's not going to happen. That's not allowed. If that were to happen, if a trustee were to do that to you, or if a creditor were to do that to you, your attorney is going to have a hearing before the judge, and the judge is going to slam that person. Judges do not put up with unprofessional, belittling conduct. Now, let's talk about what's belittling and what's not. Asking for detail about your case, that's not belittling. Asking you to get more detail, that's not belittling either. You got to do it. You got to dig. And so the main question that's going to be asked at your hearing is, number one, did you meet with an attorney and did you review this petition carefully before you signed it? You need to say yes. If that's not true, you got a problem. You get with your attorney, make sure you do review it. You should have a copy of your petition. You should feel so comfortable with that petition that you can raise your right hand and say, I swear under penalty of perjury that everything in here is true and accurate. That's important because that is what you're going to do at the hearing. Even though it's on Zoom, it is still an official hearing. You should not have to actually go down to live court during your Chapter 7 unless there's some weird issue that pops up. In 99% of the cases, that never happens. I hope it doesn't happen to you, because especially if you live in Atlanta, because going down to the Richard B. Russell building is a nightmare to park, is a nightmare to go through the security. It's much better doing everything over Zoom. So to keep your case going as smooth as possible, to get prepared for it, number one, review the petition. Number one, make sure you're ready for the question. Did you review this petition with an attorney? Yes, I did. You understand this is under penalty of perjury. What does that mean? That means if you bald-faced lie on the petition, you can go to jail. Now, that almost never happens in bankruptcy because there's no bankruptcy case on planet Earth that's worth risking jail over. Your attorney is certainly not going to do that, and neither should you. So you want to answer the questions truthfully and be as accurate as you can, but stick to the question. If the trustee asks you a question, just give them a straight answer, but you don't have to go into tons and tons of detail unless they ask you for it, and they will. When they're going through their list, they want your quick, short answer, and if they want more detail, they will ask you for it. And again, hearing should probably take 5 minutes, unless you're self-employed. If you're self-employed, those cases tend to go a lot longer because there's going to be a lot more questions about assets. Speaking of assets, the trustee will ask, did you disclose all of your assets, everything you own, even the stuff you really don't want to list? Is it all here? Yes, you want to make sure you have it all. Did you list every single debt you have in the whole wide world, even the ones you don't want to list? Are they all here? Because we have to treat the creditors fairly. Yes. The trustee may ask, do you have the right to sue anybody? Are you pursuing anybody in a workers' comp, personal injury, any type of, work case, job related case, anything? Are you suing anybody for any reason? And the reason the trustee is asking this question is because, hypothetically, if you were going to recover a significant amount of money, the trustee might have an interest in that. Well, they will. And they would want to go through that very carefully to see if the case has any value. Now, speaking of that, Georgia has a quirky law that basically says if you've got the right to sue somebody and you fail to list it in the bankruptcy case, then that creditor can come back later and it's automatically going to be deemed a value of zero if you fail to list it. So you want to make sure you have that disclosed for sure. The trustee will ask, have you paid off any loans to any family members within the last 2 years before filing this case? That's very common. People do that. The reason the trustee is asking that question is because if you did, they're likely going to sue the family member for the money and recover it. Yes, they can do that under the bankruptcy code. So let me just make up something. Hypothetically, if you paid $10,000 back to your mom because your mom loaned you money to help you get through tough times, mom's getting sued and they're going to try to recover the money. You'll still get your discharge, your debts are still wiped out. But that is why they're asking these types of questions. During the 341 hearing, it's probably a good idea for you to have your driver's license and your social security card handy, just in case. Your attorney will have already sent copies of those to the trustee ahead of time, but probably a good idea to have those just in case there's any question. Another question that a trustee is almost always going to ask is, okay, so your petition was true and accurate the day you signed it. Has anything changed since the case was filed? One of the biggies is, have you inherited anything from anybody? God forbid. I hope nobody has died, but there is the 180-day rule that if somebody does die and leave you property while this case, 180 days from the date the case is filed, technically the trustee has an interest in that. So if you inherit $1 million, the trustee is going to get their hands on it, pay off all your debts, and then give you what's left over. So that question is coming. The trustee is also going to ask if you have reviewed the bankruptcy information sheet. That's a document that your attorney should have given you. You should have a copy of that so that you will be able to answer yes to that question. Are creditors going to show up to this Zoom meeting and ask you questions? They almost never do, but yes, they do have the opportunity to do that. For example, let's say there's a car company, you have a car finance with them. They don't do it as much as they used to, but sometimes they show up because they want to make sure that the car is insured because they don't want anything bad happening to their collateral and they want to be able to recover money if something does happen. If you don't maintain insurance on the vehicle, the creditor may move to try to take it from you. Insurance is super important. I have a lot of clients who have cars that are financed for, north of 10, 15, $20,000 and they drive around with liability because they're trying to save money on their insurance and that is a violation of your contract. Read your car contract closely. There's probably a clause in there that requires you to maintain full coverage while the car is financed. What happens after the hearing is over? It'll usually end with the trustee saying, I abandon my interest in blah, blah, blah. This hearing is concluded. That's good news. Typically, people will receive a discharge in the Northern District of Georgia about 90 days after their case is filed. What could hold up a discharge? Well, something bad, like if somebody has committed fraud, if there's something the trustee feels like something has done illegally, and again, in 99% of those cases, it doesn't come up because most attorneys in the Northern District of Georgia are pretty good, and they're not going to file shaky bakey cases where the client has done something wrong. Nobody wants to deal with those kind of headaches. We screen pretty hard for that. So if an attorney has filed your case, you know, odds are you're fine. But if you feel like you have committed fraud or done something bad, you need to tell your attorney about it before the hearing so that you can avoid huge headaches. Again, for almost 99% of the clients, the last step that you need to complete after your 341 meeting of creditors is there is a class that you have to take. Make sure you take the class. Most attorneys have arrangements with companies that will automatically email them the certificate. And so we do, and we get those filed for you. If you don't take the second course, your case will not be discharged. What happens then? And you'll see some people who they have their 341 meeting of creditors and then whoosh, they just disappear and they don't take their second course. And what will eventually happen at some point is the case will be closed without discharge, meaning that your creditors can come after you anytime they want because the case will be closed without discharge, no longer active. And it's as if you never filed. Make sure you take the second course. I wish you the best of luck. And if you get a chance, check out my website, kellycanhelp.com. I've got a lot of free resources on there, and we've got a lot of stuff on our YouTube channel as well. So please subscribe. Thank you so much.